we're going to be talking about the next section of the rules, specifically competence, legal malpractice, and other civil liability. The first thing I want to point out is that this section of the rules makes up 6 to 12% of your total MPRE exam. It's one of my favorite sections of the rules because I feel like if you really memorize this, which is about a page full of rules, you can maximize your chances of success on the exam. And that's because there's not many rules here, and yet it can make up to 12% of your total exam. Therefore, I guess that's kind of a long way of encouraging you to really own this section of the rules. Because again, I think it spans such a short amount of information and yet encompasses a lot of your exam. If you understand it and know it, you're putting yourself in a great position for your exam. The first rule that I want to point out is about the competence that's necessary to undertake representation of a client. The rule states that a lawyer shall provide competent representation to a client, and that competent representation requires the legal knowledge, skill, thoroughness, and preparation reasonably necessary for representation. So just to stop there, this is essentially the basics in which we should provide for all of our clients. But what happens in other circumstances? What if there's an emergency that comes about? What are our obligations under the rules then? On that point, the rule tells us that in an emergency, a lawyer may give advice or assistance on a matter in which the lawyer does not have the skill ordinarily required. When referral to or consultation or association with another lawyer would be impractical. Even so, assistance should be limited to what is reasonably necessary in the circumstances. Let's discuss what this means, and I'll give you a quick example. What this means is these rules recognize that sometimes we as lawyers are put in a position where we might not have everything it takes to ordinarily represent a client. But the circumstances don't allow us to reach out to someone and to refer the case out to someone or to associate with someone to make sure that we're providing competent representation. For example, Anna, a lawyer, gets a call that her brother got into a terrible car accident and he's in the ICU of the local hospital. So she drops what she's doing and she rushes over to the hospital. And it turns out her brother is in terrible shape and he knows it. He requests that she draft him a will because he doesn't have one and he truly believes that he's dying. So she steps out of the ICU and she calls a friend who happens to be a probate attorney because she herself, while she's a lawyer, she practices real estate and she hasn't written a will and really doesn't know the specifics of it because that's not in her area of expertise. Thus, she steps out and tries to reach her friend who is a lawyer who can handle this type of thing. But she can't reach her friend, and she knows the time is of the essence because her brother is sitting in the hospital actively dying. After she realizes that she cannot reach her friend, she decides to go back to him and to respect his wishes and to draft a will for him, pursuant to his request. Ultimately, he ends up dying, and the will drafted in the hospital ends up being probated. If there is any sort of question about if she will be subject to discipline for her actions, the answer is no. Because that's precisely the type of emergency circumstances these rules are contemplating when it talks about allowing a lawyer to do something they might not ordinarily have the competence to do, but the circumstances simply require action. Now, the one thing I do want to point out, though, the rule makes it clear that even in an emergency where you might be permitted to act, you should still make sure that whatever you're doing is as limited as possible. So do just enough to handle the circumstances or the situation and then pass it off to someone who's more competent to take over the matter for you. So again, you're trying to keep your actions as limited as possible, even in an emergency set of circumstances. When it comes to novel fields of law, a lawyer can acquire competence through study or by associating with a lawyer of established competence in the field in question. When it comes to consulting another lawyer, the rules state that if a lawyer retains or contracts with other lawyers outside of their own firm to provide legal services to a client, the lawyer should obtain informed consent. This type of informed consent does not have to be in writing, but should occur prior to the retained lawyer consulting with other lawyers. The next rule that I want to talk about is civil liability to your client, including malpractice. Before we dive into what this specifically means, you have to get comfortable with the difference between discipline and civil liability, because it is a nuance that the examiners expect you to know. A civil case is brought in a court, in a civil court more specifically, rather than before a disciplinary board. A civil action is going to be brought against a lawyer by a plaintiff, usually a former client, rather than, say, the state bar, who would be bringing a disciplinary action against a lawyer. The whole purpose behind a civil action is for the plaintiff to derive some sort of benefit, usually damages. If a lawyer gets disciplined, the client is not getting any sort of damages. Instead, the lawyer may get suspended, disbarred, or fined. Thus, discipline and civil liability are different, and you have to keep them straight. So let's recap that. If a lawyer gets sued civilly, they're being sued in a court by a plaintiff, and the plaintiff is usually seeking money damages. So if the plaintiff wins, the benefit of that lawsuit flows to them. If a lawyer gets disciplined, they're usually being brought in front of a disciplinary board by the state bar. And if the grievance commission is successful in showing that the lawyer has violated their ethical obligations, then it usually results in anything from a warning or a fine to a suspension of their license to potential disbarment. Therefore, pay attention to the question being asked. Is the question asking if the lawyer is subject to civil liability or discipline? Additionally, keep in mind that since disciplinary actions and civil actions are separate and distinct, this means a lawyer may violate an ethical obligation and be subject to discipline. But that does not automatically mean that the lawyer could be successfully sued by a client civilly. For example, Eric is a lawyer who deals in real estate transactions, and he has a client who's very interested in purchasing a piece of property that is on the water. The client gives a $50,000 deposit to Eric with instructions to make an offer on the property and to give the $50,000 as a down payment. Eric takes the $50,000 and deposits it into his firm's operating account. Later, when he goes to make the offer on the property and to make that deposit, he checks the checking account balance and realizes that there is not enough money in that account to make that $50,000 payment. So as a result, Eric can't follow through on his client's instructions, and his client misses out on purchasing that property. When something like this happens, it's more likely than not that the client would be successful in suing the lawyer civilly, alleging malpractice. But it's also true that the lawyer's actions amounted to an ethical violation, because lawyers are supposed to keep that client property and money separate from their own. What this lawyer should have done is put that $50,000 from the client into the client trust account, not into his firm's operating account. Therefore, this one action by the lawyer is going to subject him to civil liability, meaning his client can sue him in court, and also disciplinary action in front of the state bar can be pursued. Maybe he'll be successfully disciplined, but maybe his client won't win the civil action. Who knows? The key takeaway is that they are separate and distinct actions. Now let's talk about a malpractice action that a client would bring against a lawyer or former lawyer. If a person is suing a lawyer for malpractice, one basis for this is to allege negligence. This means they'll have to prove duty, breach, actual causation, proximate causation, and harm. Turning to that element of duty, this means the plaintiff has to prove the lawyer owed a duty of care to the client. More specifically, to act as a reasonably competent and diligent attorney would owe or act under similar circumstances. When it comes to breach, it's the idea that the client has proven a duty was owed to them and the lawyer did not follow through on that duty. Now be careful though. Attorneys are not liable for what we call errors in judgment. As long as the lawyer's actions were reasonable, then there is not a breach. Turning to causation, this might be the hardest part for a plaintiff to prove. Actual causation is a but-for cause, where proximate causation is all about foreseeability. The plaintiff must prove that the injury would not have happened but for defendant's negligence, and that such an injury was foreseeable. This is a high burden to meet. Lastly, a plaintiff must prove that they've been harmed or that they have damages. There are some other actions that clients can bring against lawyers. For instance, intentional torts, things like fraud, abuse of process, or malicious prosecution. For these types of actions, plaintiffs must prove intent. They can also bring a breach of contract action against their lawyer or allege breach of a fiduciary duty. When it comes to civil liability to non-clients, there are limited instances in which a lawyer owes a duty to a third party. Usually, we think about owing duties to our clients or the people that hire us. But there is an instance when we do owe a duty to a third party. The rule states an attorney also owes a duty of care to intended third-party beneficiaries. Thus, if an attorney negligently fails to properly draft a will or a trust, making a specified person the beneficiary, that beneficiary can sue, even though they were not the attorney's client. And then lastly, I want to point out that under these ABA model rules of professional conduct, lawyers are not required to have malpractice insurance. So your state or local jurisdiction rules may require it. But for MPRE purposes, remember, you're concerned with the ABA model rules, and they do not require such insurance. So that wraps up this section of the rules.